want you to kind of pay attention to when I talk about others in practice and others that have limitations on practice. I mentioned the word government employees. An individual who is an officer or employee of the executive, legislative, judicial branch of the U.S. government or a resident commissioner may not practice in front of the IRS if it causes a violation under some other U.S. code sections 203 and 205. So if you're a government officer or you're a government employee and you're also helping individuals with tax returns, pay very particular attention to a section of that nature. And also there's sections on state officers and state employees. So let's take a look now at eligibility requirements. And as we kind of go through 10.4 and 10.5, 10.4 is eligibility, 10.5 is application processes, 10.6 is renewal, and 10.7 is representing yourself. You're allowed to represent yourself. You're allowed to participate in the rulemaking that the IRS has. 10.8 is return preparation. 10.9 is continuing education providers, and we're going to cover those this year. So 10.4, eligibility requirements for enrolled agents. So take a look at this. They'll grant enrollment to an applicant who is 18 years of age or older and who demonstrates special competence in tax matters by written examination administered by or under the oversight of the Internal Revenue Service if you possess a current, valid, preparer tax identification number. For lack of a better acronym, we call it a PTIN. If you possess a PTIN, then you're eligible for that or other prescribed identifying number. And if you've not engaged in conduct that would justify the suspension or disbarment of you as an enrolled agent. Let's take a look at the eligibility for enrolled retirement plan agents. Same thing, 18 years or of age or older, who demonstrates competence in qualified retirement plan matters. So look at the difference there. An enrolled agent, they want you to have tax competence. An enrolled retirement plan agent, they don't use the word tax competence. They only use the word retirement plan competence. And those two can differ substantially. Those two have two totally different definitions. A tax return preparer, the majority of you watching the program, 18 years of age or older. You must demonstrate competence in, look at this definition, federal tax return preparation. So do you have to have tax competence? No. Do you have to know how to prepare returns? Yes. Are you going to know how to prepare every single type of return? No. If you live in a large city, you're not preparing farming returns. You're not necessarily going to have the competence. But if you have the competence in return preparation, then you will be fine. And again, if you have a PTIN or you have another prescribed identification, then you are eligible to be eligible to this program, the annual filing season. And then finally, enrollment of former Internal Revenue Service employees. The Commission may grant, this is a special category, the Commissioner may grant enrollment as an enrolled agent or enrolled retirement plan agent to any applicant who, by virtue of past service and technical experience in the IRS, has qualified for such enrollment and who has not engaged in any conduct that would justify suspension or disbarment. So what a special category this is, that category D, they can be A or B. It doesn't really say they can be C, but of course A gives them that authority to prepare. There's kind of a little caveat there. And I do see a lot of revenue officers over the years that start their practice as revenue officers, learn the trade of tax returns and preparation and examination, and then go on to become, for lack of a better word, accountants, tax bookkeepers, and some of them enrolled agents. So you will see that in your practice if you haven't already. Okay, taking a look at section 10.5, and we're on the application, and it's the application to become an enrolled agent, enrolled retirement plan agent, or federal tax return preparer. So you must prepare an application with an address, and the address under which all correspondence regarding enrollment can be sent to. My note here is make sure the IRS knows if you move. You don't want to miss a notification from them. As I said a few minutes ago, they initiate all communication via written correspondence in the U.S. mail. So please, until that changes, until someday when that changes, and they tell you you must have a valid email address, or you must have a valid whatever it's going to be in the future. But right now, make sure they have an address where they can send you correspondence. Of course, there's a non-refundable fee may be charged to each application to become an enrolled agent. And then the examination, additional information or examinations or education such as you're doing now may be required. In some cases, they may ask you for oral examination or an oath or something of that nature. And upon a written request by you, they will afford you the opportunity to be heard with respect to your application. So if there is something wrong, if you make a written request to them, they will allow you to be heard if something is wrong with your application. And I have had some of you, again, contact me about that issue this year. So please know that you have the right to reach out. There's also a special section under here, under 10.5 subpart E. It's not on this, it's on the next slide. Let's take a look at the next slide, section 16. It's temporary recognition. I want you to know about this one too. On receipt of a properly executed application, the commissioner may grant you temporary recognition to practice, pending a determination as to whether your status will be granted. So, if you fill out an application and you want to be an enrolled agent, or you want to be an enrolled retirement agent, or you want to be a part of this program, and you fill out the application, and you have, for one reason or another, you've not satisfied all of the requirements, there is a method to get temporary recognition. It's under section 10.5B. If they deny it, you have 30 days after they deny it to file a written protest to that denial. So keep that in mind as well. And that was actually, I wanted to note that that was actually applicable starting in 2011, that they commissioned the section on temporary recognition. Let's take a look now at section 10.6, term and renewal of your status as an enrolled agent, enrolled retirement plan agent, or federal tax return preparer. So the term, if we're looking at the term, each individual authorized will be actively enrolled for a certain term. Enrollment, they'll have a registration card. I highly recommend that you carry that registration card. Talked about change of address a little bit, but take a look here. They must receive your change of address within 60 days. So when I said make sure they know of your change of address, you've got to notify them within 60 days, or else you are potentially subject to disqualification of your certificate or whatever you may have with it. If you're an attorney or a CPA, you don't notify them. You may lose your CAF number. A lot of us just use CAF numbers, and we may lose that. And when you send in this notice, make sure that you have your name, your address, your new address, your tax identification number, and the date that the address change is effective. And it becomes an important part of this. And take a look at renewal. There's all different types under subsection D. There's different years here for renewal. Enrolled agents, under this circular, you re-enroll your license with the IRS every 3 years, every subsequent third year. And depending upon your Social Security number or your tax identification number, that makes it depend on when you should have started your enrollment and when your renewal periods are up. So take a look there. Enrolled retirement plan agents, You're under Section 3 of that section, so know your renewal there. Registered tax return preparers, you must renew your PT and your status as a tax return preparer as prescribed by them. That's what you're doing annually with this filing season program, and renew that tax preparer identification number. And they will notify you of the renewal. They will issue a card or a certificate evidencing your current status. And again, we talked about the fact that, of course, they will charge a small fee for that. So let's take a look now at section, I want to skip to section 10.7, and that is slide number 18. Let me get to my slide 18. And let's take a look now. Subpart A, section 10.7. Look at the title, Representing Oneself. Participating in rulemaking, limited practice, and special appearances. And you've heard me reference these a little bit. Look at this. Individuals can appear on their own behalf. You are allowed, on your own behalf, to contact the IRS if there is an issue with your tax return. You do not have, all you have to do is present them with satisfactory identification that it is you that they are talking to. And subpart B is really interesting to me. You are allowed to participate in rulemaking. If you are interested in anything like that, you need to look at the Administrative Procedure Act. See 5 U.S. Code 553. And that'll tell you the parameters of participating in IRS rulemaking and Treasury regulations. And limitations of practice. Again, subject to the limitations, an individual who is not a practitioner may represent a taxpayer before the Internal Revenue Service in the circumstances described in this paragraph, even if the taxpayer is not present, provided you give the IRS satisfactory identification and proof of your authority. And you all know this because you handle phone calls with the IRS. You handle letters with the IRS. But look at the list of who can represent an individual. If they have proper authority, we've talked about who could have authority. If you have an individual may represent a member of his or her immediate family. In other words, I can represent my wife. I can represent my daughter. In the introductory course, that's part of the AFSP this year, you're going to hear me tell you how you can sign a tax return, how your client can sign a tax return on behalf of their children, if their children have to sign a return. Another person, a regular full-time employee of an individual employer may represent the employer. So in other words, maybe I have a person on staff, I can authorize that person to represent the company when they're talking to the IRS, and that's not an ethical violation. A general partner or a regular full-time employee of a partnership. How many of you deal with partnerships? And you may say, well, Roman, I know I have a business that I'm representing, and it has 2 owners. Is that a partnership? Most of the time, yes. It may not be considered a partnership if they're incorporated. So be careful. But either way, you'll fall under 2 or 3. And 4 gives you a bona fide officer or an employee of a corporation, an association, or an organized group. An employee of a trust, a receivership, a guardianship, or an estate. Even estates can have employees, because an estate can operate as a taxable entity, and it can have an employee. And that employee can represent itself as a special appearance. There's also things such as fiduciaries. A trustee of a trust may be able to represent the trust in front of the IRS. Something I've practiced a long time. I've practiced almost 15 years now, going on 15 years as an attorney and several years as a CPA. And one thing I learned recently was that if you have a client that is in some fiduciary capacity in a trust, there's a little tip for them. They should always have something called a certificate of trust. Here's the reason why. If you you have a fiduciary that you're filling out a return for a trust, and the trustee is there with you and saying, okay, I'm the trustee of my mom and dad's trust, and I need to fill out the trust this year, the trust tax return. It owes tax, it had income, it had properties. Let's fill out the tax return. You as a practitioner should ask them for a certificate of trust, because most likely we do trusts to hold them as private documents. No one should see a trust itself. That's why we do them as attorneys. We appoint a trustee, we appoint beneficiaries, and the trust has property, whether it be money, stocks, bonds, real estate, equipment, inventory, whatever it may, heirlooms, whatever it may be. But a certificate of trust is a notarized, signed document that swears that this is the name of the trust, this is when it was created, this is the trustee, and there's some other parameters on the certificate of trust. It's typically 1 page long. It's also a state document most of the time. In most states, you'll have a statute within your trust statutes that says, here is a sample of a certificate of trust that you can use. Illinois has one. If you need one, our office is always more than happy to send you a blank form that you could give to your trustees and say, hey, I would like you to have this filled out and notarized and signed for me. Why am I telling you that? Because then you can be assured that you are working with the only fiduciary. Just this past month from production of this program, one of my attorneys came to me and said, Roman, there's someone here, he says he's an executor of an estate, and he's claiming that he represents the estate. And of course, my answer to the attorney was, let's take a look at the copy of the will. When we read the will, of course, said there's 2 executors. 2 brothers are executors. They both have to make a decision. Therefore, we were not dealing with the fiduciary that we thought we were. A certificate of the estate, those are called something different usually, very similar though to the certificate of a trust, would help you clarify that area. So it's very important to know that. Then you know that that fiduciary can, not only can they work with you, the tax return preparer, they can represent the trust in front of the IRS. They can sign the document for the tax return. That's pretty important. Okay. Let's move on. Let's take a look at 10.8, return preparation and application of rules to other individuals. Any individual who for compensation prepares or assists with the preparation of all or substantially all of a tax return or claim for refund must have a preparer tax identification number, except as otherwise prescribed in forms, instructions. An individual must be an attorney, CPA, as we know, an enrolled agent, a registered or a federal tax return preparer to be able to obtain an FEIN number. And that's a good comment there, and we've discussed this in previous programs, that if you don't, and you'll hear this in the introductory program if you take that section as well, if you're not compensated for that return, you should not sign that return. That is one of the elements that the IRS kind of imposes on those who are not compensated. You should not sign the return as a tax return preparer. And take a look there. That's why they say under this section that preparing it, you're only subject to this if you're being compensated. Let's take a look too here at section E, preparing the tax return and furnishing information. Any individual, again, may, for compensation, prepare or assist with preparation of a tax return or claim for refund. They say appear as a witness for the taxpayer before the IRS or furnish information at the request of the Internal Revenue Service. Why would you appear as a witness, and would you even want to do that? And some of it you would be. You would want to support the position of your client. If they gave you the supporting documentation, and you believe the supporting documentation for whatever the issue is true and correct, that's what you made your decision based upon, and you want to somewhat argue that position on behalf of your client, you may appear as a witness for your client. Or you may say, look, I know he has a home office. I've been there. I've met with him at his home office. You should not disallow this deduction. I've been there. I have have a log of when I was there, or I know so-and-so was there. Those are the types of things that you can have. And be careful though, because the key word is may. It only gives you that authority if your client wants you to. It doesn't give you the authority if your client says, no, I don't want my tax return preparer to be a witness. Well, then you're not allowed to go and testify in front of the IRS. So be careful with that little element. Okay, let's take a look at section 10.9, probably one of the more important sections for this particular program. Continuing education providers and continuing education programs. Again, you're watching my tax courses online, and of course, they have to be an accredited institution. They have to be recognized for continuing education, be recognized by a qualifying organization, recognized by the IRS, have a proper number, program developed by a qualified individual. Why do I go through what I go through during the introduction? Because if you try to take a program, it must be presented by a qualified individual. It must be current. One of the problems we deal with ethics within the Internal Revenue Service, is that, to be honest, the ethical section is getting outdated. Now they've enforced it. They've stepped up enforcement. They have not gotten around to updating. Be very much on the lookout for an update to this circular at any time in the future. We don't have wind of it now as of the date of publication, but we are expecting it, especially with a brand new tax law coming down, lots and lots of changes to our tax code, lots of deductions have been stripped, lots of tax shelters have been stopped, even though we believe that there's going to be a majority of tax savings in the U.S., so many things have changed. People might be a little shocked when they do their tax returns this year. There's going to be all kinds of different structures try to be created, so be very careful and be ready for it. And then, of course, they must have a method of evaluation at the end of their program, and that is section 10.9. And I wanted to show you something. We skipped to section 10.20. We were just on section 10.9. I'm on slide 20. So 10.10 to 10.19 does not exist, and there's a reason for that. I think that's where you're going to see some updates be injected right there. So if you get a new 230, if a new 230 does come out, take an immediate look and see if section 10.10 is in there. Let's see what they end up putting in there. Okay, so we skip. We go from 10.10, 10.19, and we find the next section in the circular 230 is 10.2. And 10.2 says, information furnished to the IRS. A practitioner must, on a proper and lawful request by a duly authorized officer or employee of the Internal Revenue Service, must what? Submit records or information in any matter before the IRS. And we just have a rule of thumb. If you get a request from the IRS for information, it is a very good idea to submit that information within 1 week if you have it, and 1 month would probably not be that prompt. Although, how do they do this? How do they make a proper and lawful request? Typically, it's a subpoena. It is a written document requiring you by court order to turn over something. Or, if you're involved in an audit and they tell you, we want to see this document, and that document, and if you have them, you're going to turn them over. If you don't, they'll disallow the deduction. So that can be a proper and lawful request. But let's look at the exception at the bottom of the slide. Unless the practitioner believes in good faith and on reasonable ground that the record or information is privileged. If you send me a question on a client, and I send you back an answer, and you put that answer into that client's file, that answer is protected. That is attorney-client privilege. I don't care that you did or did not pay me $1 or $100 or whatever it may be. We still create an attorney-client relationship by me giving you back a piece of information. That answer can be protected by attorney-client privilege and does not have to be given to the IRS. You just have to make sure you have reasonable grounds that you believe in good faith, and you would in a case like that. There's going to be cases where you may argue, well, that's my work product, Roman. That's something I prepared as the tax return preparer. That's not the company information. Let's use an example, and I may use this again somewhere else in today's lecture. I think it's in the ethics portion. Have a California employer. He sends all of his employment data to his accountant. All of his hours, all of his time ticket hours for his employees, their pay dates, their payroll, their wage amounts, their dates of birth, everything. The accountant prepares all that information, puts it into a schedule, cuts the paychecks, files the 941. Upon audit, the accountant was able to withhold a compilation of the data because that's work product to the tax return preparer. That is not the source data. When the IRS audits, the only information they have a legal right to get to is the source data of the company, not the work product of the practitioner. So if you're sitting there and doing a spreadsheet or trying to determine basis in a piece of real estate, another topic to talk about in the introduction, if you have a spreadsheet where you kind of figured out what their basis was based upon documentation that the client gave work product, you can hold that as work product and not turn that over. That's not subject to that. You can believe in good faith and reasonable grounds that information is privileged to you, and you're not being subjected to your in-house information. Okay. Section 10.2, still on information furnished to the Internal Revenue Code. And again, attorney-client privilege. Now, where do we get outside of it? If there is a actual court case, actual tax court case, and then maybe you are subpoenaed, you are deposed, then we start maybe getting outside of that. And how to tell? How do you tell if it's privileged? You know what? Ask. Ask the attorney that maybe did the document, request it in writing from them, ask them. Find out what they're going to say. 10.22, I want to highlight, though, we don't have a slide on 10.21, but I want to highlight 10.21. Because 10.21 is knowledge of your client's omission as it relates to this slide 10.20, slide 22, information that's being furnished, and also 10.22, diligence as to accuracy. So 10.21 is knowledge of clients' omissions. Typically, the knowledge is that you know they're underreporting their income. You know that could cause them penalties and tax. You know the deduction is going to be disallowed. Had a case this year, very recently, that a client bought a boat, wanted to have the boat brought over to the United States, wanted to lease the boat, wanted to be able to deduct the boat for business purposes, was running the boat for business purposes. Due to the circumstances, some things happened, some things didn't happen. The CPA involved actually did a good job. Took the client's data when they purchased the boat and were getting the boat ready to be rented. Took certain deductions for the boat based upon the client's representation. The client got audited. Boats are a high audit target in a business unless you're running fishing charters or things of that nature. It starts to blur the lines. I'm a pilot. I have an airplane. Airplanes are a high target on IRS tax audits. There's certain items that are. This one was. What happened in this case? The IRS disallowed the deductions, but did not find fault by the CPA and by the bookkeeper. There was not an omission. The client didn't purposely underreport, didn't purposely take a deduction that they weren't going to get. There was factors that happened with the boat that caused the boat not to end up being what we call placed in service. So the tax structure of the transaction changed because the item wasn't placed in service. But the key was, if the accountant had known that was going to happen down the road and had purposely omitted or purposely taken deductions and omitted that knowledge, then you're liable under 10.21.
Okay. Okay.